there are two basic statutes that could theoretically help. On paper, they should help a lot. And ironically, they're both Title VI's. So it's not a mistake, it's really both Title VI's. One Title VI of the Civil Rights Act of 1964, and the other Title VI of the Federal Education Act, Higher Education Act. Now, the Federal Higher Education Act says it's the act that provides funding for Middle Eastern programs throughout the country. Now, there were studies done, especially by AMCHA, the AMCHA initiative in the West Coast, that showed that they were, and is a very good report that I put online, available for you from the Brandeis Center about this statute. The survey showed that these programs were absolutely disproportionately biased against Israel, and anti-Semitic in many instances. Terribly disproportionately biased. So the Congress went back and amended the statute. It amended the statute to say that it can't be biased. Very nice. However, number one, there is no process for monitoring whether they're biased or not. Number two, there's no process for individuals to file complaints asserting that there's bias. Number three, there's no sanction in case there would be a finding, although there's no one looking, but if there would be a finding of bias, there's no sanction involved. And this is, so on paper, we shouldn't be paying for disproportionately biased programs, but we have to address it by getting the statute changed to put teeth in it. Congress has agreed in principle that it doesn't want it to be biased. We have to get them to act on this. Second thing is the Title VI of the Civil Rights Act of 1964. Now there was a effort, and I think Kenneth Marcus is responsible for the success of it. Kenneth Marcus and Susan Tuchman of the Zionist Organization of America, and getting the Justice Department, getting the federal government to recognize that discrimination against Jews, Jewish students, is also prohibited by Title VI of the Civil Rights Act of 1964. Unfortunately, the government is not enforcing it. Just not enforcing it. I mean, I got off the phone with Susan Tuchman this week, and she told me, for example, about a case at Rutgers. Case at Rutgers, there were death threats about somebody. And an administrator at Rutgers threatened this newspaper student, a journalist at the newspaper. And what happened? And there were 6 other students who complained about this hostile environment there. And what happened was the government spent 3 years before even responding. And then it said, no, we don't find a problem. And then, when they appealed, they're still waiting. They appealed it, I think, in 2014, maybe. And they're still waiting for a response on the appeal. In commentary, there was an article on the earlier problem at Irvine in California, where Kenneth Marcus reported in a small 6-page article that the professionals in the federal government who deal with this found that there was a violation of Title VI, but the politicians in Washington told them to find that there wasn't. So we have these 2 statutes which, Title VI, you say you can't discriminate against Jewish students, and it can't be a hostile environment, but we have a very hostile environment on a number of campuses. We don't have redress.